Host of Late Night Seth Meyers summarized a Fox News town hall in which Donald Trump attempted to claim that Joe Biden had the mental capacity to be president. In this episode, Meyers emphasized Trump's own articulation difficulties, pointing out that Trump finds it difficult to use the term cognitive decline, instead opting for cognitively not good, to which Maya made a hilarious remark. Not even the monster from Frankenstein could top it. Then there was poor cognitive performance. I'll walk you through everything in this video. Please click the subscribe button and enable notifications before I continue so that you may begin receiving our daily breaking news. I'm grateful. He claimed that it is no longer sufficient to just state that Fox News is pro-GOP and that the town hall provided additional proof of the close ties between Fox News and Trump. The GOP represents them. That thing is indistinguishable. In addition, Meyers highlighted moments in which Trump appeared to be confused about fundamental information, such as the city he was in and his false assertion that a photo ID is required in order to purchase bread. Customers made jokes about Trump's seeming lack of knowledge about daily duties like buying bread. Meyers addressed Trump's seeming authoritarian inclinations in a different way, pointing out that he has shown a clear and constant wish to establish himself as dictator should he be elected to another term. He brought up a conversation he had with Sean Hannity in which Trump joked about not being a dictator. Aside from the first day, the emphasis was on drilling policies and border control. Jimmy Kimmel also offered his thoughts on Trump's exclusion from the fourth Republican presidential debate, drawing a comparison between it and an NCC reunion without Justin Timberlake. In a lighthearted response, Kimmel pointed out how ridiculous Trump's claim that he would not be a dictator was. These late-night TV segments are a reflection of the constant criticism and humor. Regarding Trump's public pronouncements and political maneuvers, they perfectly capture the tone that frequently permeates public discourse regarding Trump's behavior and the possible ramifications for American politics, a blend of comedy and grave anxiety. Late-night entertainers and analysts such as Seth Meyers, Jimmy Kimmel, and Charlemagne the God are highlighting the unique and worrisome aspects of Donald Trump's discourse, especially when it comes to the idea of him becoming a tyrant, with witty yet sharp criticisms. Meyers and Kimmel draw attention to the ridiculousness of Trump's claims as well as the strange nature of the discussions around his campaign, emphasizing the necessity for Sean Hannity to specifically urge Trump to commit. This need to inquire about a prospective future president in order to avoid becoming a tyrant is itself seen as concerning and illustrative of the unorthodox and unsettling elements of Trump's political strategy. These thoughts were mirrored by Charlemagne of the Gods, who was a guest host on The Daily Show. He emphasized that people are not giving enough credence to what Trump has said and that he has been quite clear about his intentions. He uses the example of asking a babysitter whether they're going to devour your kids to make the point that, given the events leading up to the legal procedures, the necessity of raising such concerns is concerning in and of itself. Former prosecutor Joyce Vance discussed Judge Aileen Cannon's acts of the U.S. District Court for the Southern District of Florida, including former President Donald Trump. During an interview with MSNBC's Katie Fong, critics lambasted the judge for his inexplicably slow handling of the criminal case concerning documents found at Trump's Mar-a-Lago estate. How do you feel about this topic? Kindly share your thoughts and opinions in the comments section. Let's have a discussion. The D.C. Circuit Court of Appeals' decision to take up the matter of presidential immunity, which has significantly delayed the start of Trump's trial originally set for January 6, was applauded by Vance. She compared this to the Steve Bannon case, where Trump's approach of delay is seen as intended to surpass the election and potentially resolve matters to his advantage if he is re-elected. Special counsel Jack Smith discussed the obstruction of justice allegations against Trump. Accusations have been made against Trump for stealing sensitive government documents, keeping them at his Mar-a-Lago home, and then refusing to return them. Vance indicated hope for the current state of affairs in Washington, pointing out that the legal system sometimes operates at a sluggish pace. However, recent proceedings in both courts have moved rather quickly. Furthermore, according to ABC News coverage on January 8, Special counsel Jack Smith's team apparently obtained additional incriminating information from one of Trump's closest allies, Dan Scavino. This fresh material purports to underscore Trump's alleged inaction during the incident and offers a new angle for the investigations into the Capitol disturbance on January 6. The disclosures made by Dan Scavino, a former deputy chief of staff for President Trump who is currently a senior advisor on a paid basis to his re-election campaign, are important because they shed light on former President Donald Trump's reaction to the Capitol siege on January 6. Scavino Scavino's evidence exposes Trump's unwillingness to step in and put an end to the violence as it grew, according to ABC News sources who are aware of the special counsel's probe. According to reports, Scavino's account contains information about Trump's seeming lack of interest in intervening amid the chaos, which presents an unsettling image of the former president's handling of the situation. Furthermore, Mick Luna, another former Trump employee, reportedly briefed federal investigators that Trump responded with indifference upon learning of Vice President Mike Pence's safety, callously saying, "So what?" If accurate, this response suggests a lack of concern for Pence's security and an unexpected willingness to expose a loyal comrade to potential harm. Trump's actions on January 6 have already drawn criticism from the House Select Committee, which called them a flagrant moral failure and duty neglect. Scavino's account supplements the bigger probe by special counsel Jack Smith's team, which is delving into obscure facts regarding Trump's role in the violence in the nation's capital. Scavino's and other notable people's testimony is essential to understanding Trump's behavior and decision-making on that crazy day. Assuring Trump that the day's events would live on in his memory, Scavino pushed him to help arrange a smooth handover of power. But Trump's response did not live up to Scavino's hopes for a swift and successful conclusion to his presidency. Scavino and Luna, among other Trump officials, attempted, but were unable, to persuade the president to make a comforting remark in the face of the mounting violence. Scavino's denial of involvement in the tweet and his attempts to calm the situation have been highlighted as particularly concerning aspects of Trump's anger and his eventual tweet criticizing Pence for lacking the guts to overturn the election results. These actions also revealed internal strife within Trump's team as the crisis developed. Donald Trump, the former president, was dealing with a number of legal issues, including inquiries into the events surrounding his involvement in the Capitol unrest on January 6 and matters concerning sensitive materials discovered at his Mar-a-Lago residence. It is true that special counsel Jack Smith worked on several of these cases. The legality of presidential immunity is complicated. While a sitting president often has certain privileges, these may not always apply to actions done after leaving office or outside the purview of their official duties. According to constitutional law scholar Michael Gerhardt, there would undoubtedly be a great deal of legal argument and interpretation over the scope and nature of any legal immunity that a former president might claim. Donald Trump's purported incitement of the January 6 insurrection may bar him from ever holding public office again under a reasonable interpretation of the 14th Amendment. During an interview with Danielle Moody, co-host of The New Abnormal, Gerhardt clarified that participating in insurrection or instigating rebellion disqualifies U.S. officers from taking the oath of office again. What is your opinion on this matter for a federal post as defined by Section 3 of the 14th Amendment? Kindly share your thoughts, and let's have a discussion in the comments. Gerhardt emphasized that the evidence implies that Trump was trying to stop Congress from certifying the election results. This evidence includes videos of Trump's findings from the January committee and numerous insider stories. Gerhardt argues that this intervention violates both the congressional and constitutional processes involved in selecting a president. However, Gerhardt expressed doubts about the likelihood of Trump's conviction in this case. Gerhardt, though, voiced doubts about the possibility of convicting Trump in this case, given the number of conservative Supreme Court justices. Considering the number of conservative Supreme Court justices, he hinted that the court might interpret the law incorrectly or ignore its plain language in order to come to a result that is in line with the wishes of its constituents. Letitia James, the Attorney General of New York, is pursuing severe penalties against former President Donald Trump in a different legal case on suspicion of fraud involving real estate deals and property appraisals. In a fraud action, James initially charged Trump with controlling real estate values for his personal benefit. From the original $250 million estimate to the anticipated $707 million in fines, there has been a considerable escalation. James wants to ban Trump from ever working in the New York State real estate market, and this is a major part of her complaint. Mary Trump, Donald Trump's niece, voiced her opinions about the effects of these legal challenges on her uncle in the midst of these occurrences. Mary Trump's most recent Substack article, Letitia Screws Donald Even More Than You Think, released on Friday, revealed that Donald Trump had an especially difficult day. She implied that the legal developments had made his problems much worse. There was strong division and debate surrounding the trial. Known for her unwavering support of Trump, Marjorie Taylor Greene took to social media to share her opinions about the worsening legal scenario while New York Attorney General Letitia James was pursuing a $370 million fine in the civil fraud case against Trump. He responded in typical furious and protective fashion. Using his powerful social platform, Trump vehemently attacked the lawsuit that accused James of being completely dishonest. and making that their priority. They should pay me without offering any hard proof to back up his assertions. This response is in line with Trump's long-standing practice of using forceful language and defaming his accusers in response to legal challenges. The state of affairs concerning Trump's real estate, Mar-a-Lago, in particular, makes his legal issues even more complicated. As previously noted, there is conjecture around Mar-a-Lago's future, particularly in light of the Trump Organization's dissolution, which owns the property. Joe Gallinez is an attorney. Findings imply that Mar-a-Lago might not have the same legal protections as a traditional home in Florida because it is a members-only club with visitor rooms. This makes one wonder what effect Judge Arthur Engoron's impending decision would have on the land. Mary Trump's assessment of the circumstances was drawn from her discussions with legal specialists. Her assessment, drawn from discussions with legal specialists, suggests a potential significant change in her uncle's situation. Her viewpoint as a member of the Trump family gives the public conversation about these legal disputes a more intimate touch. She sees the current difficulties as a fitting coda to a lifetime of her uncle's dishonesty and Blenheim manipulation, which had their roots in their grandfather's heritage. Stay tuned, as we'll be covering every turn and twist of this rapidly developing story. Please share your opinions in the comments section. For more updates, don't forget to like and subscribe. The Supreme Court has concluded the legal arguments supporting Trump's exclusion from the 2024 presidential contest. Today, the Supreme Court rendered a decision that satisfied everybody. I'll go over everything with you in this brief video. If you enjoy politics and want to stay informed about everything happening in America, please hit the subscribe button. That is what we do every single day. I'm grateful. Widespread criticism greeted the Colorado Supreme Court's decision to strike Donald Trump from the state's primary ballot under Section 3 of the 14th Amendment, which states that an individual has sworn allegiance to the Constitution and then launched an insurrection against a government that is unable to fulfill its duties. The Secretary of State of Maine later elicited a similar response when she took a similar measure in her state. These decisions have received a majority of incorrect criticism that requires revision. One of the 6 most prevalent and false criticisms is that, acting now, Congress must ensure that Trump is not given due process. A criminal history is necessary for disqualification. The only remedy after an indictment is conviction. 14(3) excludes the presidency by its terms, which is incorrectly anti-democratic. It is easiest to dispute the assertion that congressional action is required. According to certain constitutional academics, 14(3) is, in legalese, self-enforcing, as stated in the majority conclusion in Colorado. In other words, it can be enforced on its own terms without the need for law enforcement. But here's your chance to get Congress to take action. The majority of the House and Senate voted in favor of the second impeachment in 2021, finding former President Trump's behavior precisely outlined in the article of impeachment named Incitement of Insurrection, with a 14.3 ratio. Naturally, the Senate did not vote with the required 2/3 majority to convict following the House's impeachment. A second term would be immediately barred by this, but let's not forget that 57 senators voted in favor of a conviction. This vote supports the finding that Trump engaged in the behavior outlined in Article 14.3. Without a doubt, Donald Trump is entitled to due process under the Constitution. What exactly and to what extent does due process apply? Stricter guidelines are necessary since the ballot removal procedure in this unprecedented situation is a civil matter rather than a criminal case. Trump's attorneys actively engaged in the 5-day evidence and witness trial that took place in Colorado District Court. Trump and his attorneys made the most of their numerous chances to argue their case, both during the trial and on appeal. Due to Colorado's election law, the primary must be certified by January 5, imposing strict deadlines for trials and appeals. Are further due process proceedings possible given the extra time and pre-trial procedures? However, this does not imply that Trump is not afforded the due process demanded by the Constitution. Remember that there was a significant amount of due process involved in the aforementioned 2021 impeachment procedures. Before the Senate jury, Trump was once again represented by attorneys. This time, the majority of jurors found him guilty. We now address the frequently made claim that a criminal record is necessary for disqualification under Section 14(3), which is only a statement. The text and history of the 14th or the 3 do not support this claim. We should once again acknowledge the majority's finding in the previous president's second impeachment, which stated that Trump engaged in the behavior specified in 14(3), providing justification for removal. Is the sole recourse an indictment and conviction? There's no doubt that the 14 drafters were aware of the Constitution's clauses on impeachment. Had they believed that impeachment was the sole means of handling a former president who was an insurrectionist, they would have made that statement. It is probable that this situation did not affect them. Consequently, all that remains is the obvious interpretation of verse 14:3 and its obvious relevance. What exactly the title, United States officer, means is still a mystery. Does the president fall into this category? The Colorado trial court's refusal to read the word to encompass the presidency served as the foundation for its ruling. Not all members of the Colorado Supreme Court were as hesitant. He pointed out that the president's office was mentioned numerous times in the Constitution. The majority opinion transcended semantics to the plain meaning of the text, believing the president to be an officer of the United States. Thus, the gravest grievance still stands. Removing Trump via 14.3 would be falsely anti-democratic. This is not a legal concern, rather, it is a political one. I sincerely appreciate you staying until the very end. Please share your thoughts about this news with us in the comments below, and don't forget to hit the subscribe button and give us a thumbs up. See you in the upcoming news. America, God bless you. Goodbye.